Abby Groh, I'm the president of ACS here, and we are excited to co-sponsor this event with Federalist Society. We are very lucky to have Amy Howe, the editor of SCOTUSblog, here to tell us about this upcoming term in the Supreme Court, and she's going to have a lot of good information for you to keep an eye on what they're doing. And we want to remind you about our two Gideon events next week. Tuesday we have the Public Defenders panel at noon, and Thursday we have Karen Hoopert, who wrote Chasing Gideon. She's also at noon here in the moot court room. And I'll introduce Adam, and he can talk about Federalist Society, and then we'll get started. Thank you for coming.
My name is Adam Dorr. I'm the president of the Federalist Society, and we are the poster that just fell down. But you see me, so I'm here to remind you that Federalist Society is also co-sponsoring this event. Really excited to do this with ACS. I think we have similar goals, trying to stimulate debate on current legal issues that are really affecting our nation, and really talking about the issues that are coming up at the Supreme Court really fosters that goal. We do that from by bringing in speakers that tend to come from a conservative or libertarian perspective, focusing on limited constitutional government. ACS brings in speakers from the other side, but all together really striving to gain a deeper understanding of these issues, and so that we can have a more informed and educated debate. In fact, next month we'll be hosting an event on one of these cases that is before the Supreme Court next month, called Town of Greece versus Galloway, which is an Establishment Clause case. So if that's something that discussion today spurs your interest, would encourage you to keep an eye on the ILA for that event that we have. Now, at this time, I would like to introduce the person who will be doing the introduction, Professor Conkle. He's a longtime constitutional law professor at this law school. He got his undergrad and JD from Ohio State, so I guess it makes him a double Buckeye or something like that. He has been at the law school since 1983. His research really addresses a lot of constitutional law issues, religious liberty, the role of religion in American law and politics, and he is an amazing professor, and I enjoy listening to him in Con Law 2 every Monday, Tuesday, and Wednesday morning. So with that, I'd like to introduce Professor Conkle.
Thank you, Adam. I think we are really, really privileged to have Amy Howe with us today. She is a remarkably accomplished lawyer, law teacher, and dare I say, journalist. And I want to add that specifically because she tells me that she has an application pending to get her media credential to from the Supreme Court. So let's make sure she's recognized as a journalist as well as a lawyer and teacher. She is a graduate of Georgetown University Law Center. She has taught Supreme Court litigation at Stanford and Harvard. She's taught as well at Vanderbilt University and American University's Washington College of Law. As a lawyer, her practice focused on appellate litigation, including the Supreme Court, where she argued 2 cases and was counsel in many, many others. Back in October of 2002, 11 years ago, Ms. Howe was a partner with her husband, Tom Goldstein, in a 2-person Washington, D.C. firm that specialized in Supreme Court litigation, and she and her husband thought it might be of interest perhaps to create a blog focusing on the Supreme Court. Might generate business, might enhance the practice a bit, and as they say, the rest is history. SCOTUSblog launched in October of 2002, took on a life of its own. It has become quite clearly the go-to website for people who are interested in the Supreme Court. It is used by not only lawyers, law professors, law students, but by citizens at large. It provides unbiased and comprehensive coverage of the Supreme Court, not simply on constitutional issues, but on the entire range of questions that the Supreme Court, in fact, undertakes to decide. It provides high-quality commentary, almost instantaneous access to the Supreme Court's orders and decisions. It is truly a remarkable journalistic accomplishment in the new media age, and it has been recognized as such, receiving awards not only from the American Bar Association, but also from the Society of Professional Journalists. And it's the first blog ever to receive the Peabody Award for Excellence in Electronic Media. And Ms. Howe has been instrumental in that innovation of the SCOTUSblog, working for the blog for most of its 11-year history. She currently is the editor of blog, and that now is her full-time job. Needless to say, Ms. Howe is an extremely informed observer of the Supreme Court, And again, we're very lucky to have her with us. As already noted, she'll be talking about the current Supreme Court term and some of the issues that the Supreme Court will take up. She plans to talk, as I understand it, for maybe 35, 40 minutes, and then there will be time for questions at the end. So please help me in welcoming Amy Howe. Thanks for coming.
Well, thank you for that wonderful introduction. I have one minor correction, which is when you talked about that it was Tom's and my idea to form the blog. He came to me, I have to say, in the interest of full disclosure, and said, I've got this great idea, I think we should start a blog. My first reaction was that I didn't know what a blog was, and my second reaction was that I actually thought it was a terrible idea. I was 8 months pregnant at the time. We were doing a gut job renovation of our house, and I really thought that the last thing I needed was another job. It is now my full-time job, and as I've said to a couple of you since I've gotten to Bloomington, I get up in the morning some days to go down to the Supreme Court to cover the cases or to cover the decisions and think, I can't believe that this is my job, and I feel so lucky to have it. So we're going to talk a little bit, I'm going to talk for about 30 minutes. The game plan is that we're really not going to be able to get into any depth in any of the cases because I want to try and cover some of the highlights, and also because I know that many of you are first-year students and I don't want to get too far into the weeds of some of these issues. But having said that, if you have more substantive questions, I hope you'll raise them during the Q&A, and I also hope that some of the law professors here who know way more about some of these topics than I do will also weigh in. I want to start any good review, I think any good preview starts by looking back at the term before. And this was a blockbuster term that followed another blockbuster term, and it was the third full term for these 9 justices together. And the last full week of the court's term was a real roller coaster in particular. On Monday, the court issued its decision in Fisher versus University of Texas at Austin. It was the affirmative action challenge to that university's use of race in its undergraduate admissions process. And that was really a case, I think, in which both sides claimed victory. I think that the supporters of affirmative action were relieved that it survived to fight another day. The challengers felt vindicated because the court, I think any fair reading, put some serious new restrictions on, although unclear how many, on when universities can use affirmative action. On Tuesday of that week, we had the decision in Shelby County versus Holder, the voting rights case, and the court left Section 5 of the Voting Rights Act, which contains the pre-approval requirement, the requirement that state and local governments with a history of discrimination in voting go to the Department of Justice or go to a 3-judge district court in D.C. for clearance for any changes that they want to make to their voting procedures, no matter how minor. So Section 5 stayed intact, but the court invalidated Section 4 of the Voting Rights Act, which contains the coverage requirement, the formula that's used to determine who needs to comply with Section 5. And then on Wednesday of that week, we had the decision in the same-sex marriage cases. That was where the court struck down Section 3 of the Federal Defense of Marriage Act. A different group of 5 justices held that the supporters of California's ban on same-sex marriage lacked the legal right to defend Proposition 8 on appeal, and so it didn't reach the merits of the case. And so those 2 decisions collectively left a lot of questions open about the standard of review for future cases involving challenges to bans on same-sex marriage. I don't think it's a coincidence that the decision in United States versus Windsor didn't clearly say what the standard of review was. And hearing people talk about it since then, it seems to me like one of those paintings that different people see in it what they want to see. And so the Chief Justice's dissent was written in no small part to make clear that he saw it as a matter of federalism, that the states going forward get to decide issues relating to same-sex marriage. I've done panels with folks who are in the trenches litigating the challenges to same-sex marriage, and they see it as an equal protection decision. What we do know, I think, is that the court would really like to wait a long time before it has to deal with same-sex marriage again. Justice Kennedy gave a speech in March before the arguments in the cases, and he said, we shouldn't be deciding all of these hot-button issues. There are some things that should be left to the executive branch and to the legislative branch. And I think really the court no matter how five justices, or at least five justices ultimately feel, it doesn't want to be in a position where it is striking down the laws of over 30 states. In Loving versus Virginia, the challenge to Virginia's ban on interracial marriages, it was able to wait until there were only 16 states that had such a ban. But I'm not sure that it's going to have the luxury of time to let the political process and let the states work out the issues on their own. There are a whole host of challenges all over the country that are bubbling up and headed toward the Supreme Court. Some of them are headed there. Their litigators hope quite quickly. A week or so ago, David Boies and Ted Olson, who were the lawyers behind the Proposition 8 challenge, announced that they were challenging Virginia's ban on same-sex marriage. There is another case in another federal district court in Virginia that is also trying to be the first one to get to the Supreme Court. And one of the lawyers in that case is Paul Smith, who argued successfully in Lawrence versus Texas. So the court may not have the luxury of the time that it would like. So far, this is we don't know what all of the court's cases for this term are going to be. We do know, have a pretty good sense of some of them, and we know what some of them are coming down the pike. The sense is that this is not going to be a term like the last two terms in which you have blockbuster after blockbuster. I think the court, as Justice Kennedy's speech in March would reflect, might be okay with a docket full of really interesting and consequential cases, but not one that's going to have, all of the cameras outside the court on the last day of the term. Because it's a deep bench, even if not one with a handful of superstars. It's also a docket that some people have called a season of sequels, because the court seems like it's going to be revisiting a lot of issues, some that it has visited quite recently, others, cases going back 30 years. It'll be the first time that the Roberts Court, for example, has weighed in on issues like recess appointments, legislative prayer, and abortion protests. So it'll really, I think, give us a better sense of where the Roberts Court is headed, even if, as we'll talk a little bit about at the end, we don't know exactly how long we will have this particular Roberts Court. The first big case of the term has already been argued. It was a case called McCutcheon versus FEC, Federal Election Commission, that was argued on the second day of the October sitting. In 1976, in a case called Buckley versus Vallejo, the court held that the government could put more restrictions on campaign contributions than it could on spending by candidates and political committees. And the rationale for that was that campaign contributions are more likely to corrupt the process. In 2010, the court issued its decision in the Citizens United case, and in that case, it struck down the limits on expenditures by unions and corporations, as long as those expenditures were to political committees that are independent of a particular election. And so that case was about spending, which created a little bit of a weird dynamic. Federal law creates base limits on how much you can give to a particular candidate for federal office, and then it also has aggregate limits on how much you can give to candidates for federal office during a 2-year election cycle. And so currently that's $48,000 to federal candidates, and then another $74,000 to political parties and political committees that are affiliated with the parties. But at the same time, you can give unlimited amounts of money now to independent political action committees. And so we saw this during the 2012 presidential campaign. You had a Nevada billionaire named Sheldon Adelson who was able to give millions to an independent PAC that was created to promote the candidacy of Newt Gingrich. This case is about contributions. It was brought by an Alabama businessman named Sean McCutcheon, and he's not challenging what's known as the base limits, the $2,600 that he can give to a particular candidate. He's challenging what we call the aggregate limits. He says he wants to be able to give $2,600 to more candidates. He wants to be able to give more money to the RNC, and the RNC says that it wants to be able to take more money from people like Sean McCutcheon. The D.C. Circuit upheld the aggregate limits against McCutcheon's challenge, and so the Roberts Court heard oral argument at the beginning of this term. The Roberts Court has had, before McCutcheon, 5 First Amendment challenges to various campaign finance restrictions, and the challengers have won in all 5. So this is a theme I'm going to return to a couple of times today. This was a case in which at the point that the court announced that it was going to grant review, The question wasn't so much whether it was going to affirm or reverse, but sort of how big the victory might be for opponents of campaign finance regulations. Was it going to be a huge victory, or was it going to be a more limited one? It was not entirely clear after the oral argument. Those of you who think of the Supreme Court as having these grand constitutional debates would have been very disappointed at the McCutcheon argument. It was really sort of the justices diving into the nitty-gritty of how campaign finance schemes work in practice. Many of us think of Anthony Kennedy as the pivotal vote on the court, but it looked like the pivotal vote in McCutcheon could well be the Chief Justice. And the Chief Justice was at least not opposed to the idea that if an individual is able to give millions of dollars to political parties and political committees, that might create a problem, that it might create the appearance of corruption. But what he was concerned about was what he called the small donors. And you don't necessarily think of people who can give $50,000 to candidates small donors, but that sort of the artificial idea that you can give to 9 candidates under the law as it currently stands, and that's not considered corrupting, but at the point that you give money to the 10th candidate, that is considered corrupting. And so it looked like maybe he was trying to reach some sort of compromise in which you would strike down the aggregate limits on individual contributions, but maintain them with regard to political parties and political committees. It's not clear that he could get 5 votes for that, is the problem from his perspective. The other conservatives seemed totally on board with the idea that the aggregate limits should go. In their view, there's already so much money in campaigns that adding a little bit more isn't necessarily going to add any corruption. Justice Scalia described it as fanciful to think that a candidate for federal office is more likely to be corrupted by a large contribution to the RNC than she would be by a large contribution to a political action committee that then proceeds to spend lots of money on her election in her state. So that was McCutcheon. The next case that, again, one that has already been argued, is a case called Schuette versus Coalition to Defend Affirmative Action. This has its roots in the court's 2003 decision in Grutter versus Bollinger. In that case, that was the precursor to the Fisher case. The court in that case, in an opinion by Justice O'Connor, held that the University of Michigan Law School could use race as one factor in its admissions process as part of its efforts to create a diverse student body. After the court's decision in Grutter, a couple of years later in 2006, Michigan voters approved a referendum called Proposal 2 by a margin of 58 to 42%. And what Proposal 2 says, at least as relevant to this case, is that state universities in Michigan cannot use race as a factor in their admissions process. So the Fisher case was about whether or not a university could use affirmative action in its admissions process. The Schuette case is about whether or not the state can ban the use of affirmative action in its admissions process. The Sixth Circuit held that Proposal 2 was unconstitutional. It relied on something called the political restructuring doctrine, which dates back to 2 cases from 1969 to 1982, which says that when you distort the political process to make it more difficult for minorities to advocate on behalf of change, here on behalf of affirmative action, that's unconstitutional. Again, this is a case that you had the sense that the court took to reverse, and again, the question is how big. After the oral argument, the Chief Justice, Justice Scalia, and presumably Justice Thomas seemed like sure votes to uphold Proposal 2. Justice Kagan was recused. Justice Ginsburg and Justice Sotomayor seemed like they would vote to strike down Proposal 2. Justice Breyer seemed to be trying to get a critical mass behind the idea that even if in some scenarios you could ban the use of affirmative action at different levels of government, at the point that you enshrine a ban on affirmative action in the state constitution, that does so distort the political process as to be unconstitutional. Justice Kennedy seemed, possibly receptive, and there were some comments by Justice Alito that suggested that he might be as well, but we will not know until we get the decision probably sometime next year. Next month, the court will hear oral arguments on legislative prayer for the first time in 30 years in a case called Town of Greece versus Galloway. 30 years ago, in a case called Marsh versus Chambers, the court held that prayers at the start by a chaplain, a Christian chaplain, at the start of the Nebraska legislature's session were not unconstitutional. And since 1999, the town of Greece, which is a small town outside of Rochester in upstate New York, has started its town council meetings with a prayer. This case was filed in 2007 by a woman named Susan Galloway, who was Jewish and who said that the repeated use of Christian prayers at the town council meetings made her uncomfortable. From 2004 until 2008, 3/4 of the prayers were offered by Christian ministers. In 2008, there were only 4 that were non-Christian. And just to give you a sense of the content of some of the prayers, there was one prayer this summer that was offered by a Christian minister who thanked God for the freedom that comes from knowing your son Jesus. The Second Circuit held that the prayers were unconstitutional because it suggested that the town was endorsing religion. The town took the case to the Supreme Court, which granted review. The Second Circuit said it wasn't enough that in theory other religions could be represented at the prayers, that were represented, that the town hadn't made enough of an effort to let other religions know that the opportunity was there and to recruit ministers from other faiths. The town of Greece, in its brief on the merits, is urging the Supreme Court to get rid of what's known as the endorsement test that the Second Circuit used altogether, and to instead use something called the coercion test, which means that the prayers would only be unconstitutional if they coerced someone into believing the message of the prayers. The town of Greece tells the court that the endorsement test essentially is too squishy, that to apply it, courts would need to look at the content of individual prayers and try to figure out whether or not a reasonable observer would believe that the town was endorsing religion with that particular prayer. The town says that Marsh allows prayers as long as you're not proselytizing or denouncing another religion, and there's no discrimination in terms of who can offer the prayer. And it says none of those factors are present here. To the surprise of some, the Obama administration filed a brief that is mostly supportive of the town, but remember that Congress starts all of its sessions with a prayer. The federal government agrees with the town of Greece essentially on Marsh versus Chambers. It says that you can have prayers as long as you're not proselytizing or denouncing other religions. Susan Galloway says that even if you apply the coercion test, this is coercion. If maybe in Congress or at the Nebraska legislature where you have a choice about whether or not you want to show up and watch Congress in action. Here, if you want to participate in the town council sessions, which is the reason that most people go to them, if you want a permit, you want to testify, you have to sit there for the prayer and you feel coerced into participating in the prayer. And so in terms of whether or not, if this is a case that the court took to reverse, could the court reverse relying on Marsh versus Chambers and say Marsh versus Chambers is still good law but you can pass under Marsh versus Chambers, or will it scrap the endorsement test altogether and go with the coercion test that the town of Greece has suggested? And we'll get a much better idea after the oral arguments in November. We have 2 cases on the court's docket relating to abortion. The first one that I want to talk about is sort of where abortion and the First Amendment meet. Federal laws, as many of you know, provide some protection for women who want to gain access to abortion clinics, but some states have enacted laws to provide more protection to women. In 2000, the court reviewed one such law in a case called Hill versus Colorado, and it upheld the law. The Colorado law created a 100-foot buffer zone around healthcare facilities, and then it told protesters that they could not go within 8 feet of women within that buffer zone to protest. And the court said that law was constitutional. It said it's a reasonable content-based regulation that balances the need for women to be able to get into the clinic unencumbered with the need of the protesters to make themselves heard. So the new case is a challenge to a Massachusetts law that creates a 35-foot buffer zone around a reproductive health care facility and says that protesters can't go into that buffer zone at all to protest. It allows clinic employees to go into that buffer zone and speak as long as they're speaking within the scope of their employment. The challengers here say that unlike Hill, this law is viewpoint-based. The clinic employees can go in there and talk to the women, but the protesters cannot. It only applies to abortion clinics. And they say that with regard to 3 abortion clinics in Massachusetts in particular, the way the buffer zone is drawn, they have no other way to get their message across. The Hill decision was a 6-3 decision. Justices Ginsburg, Breyer, O'Connor, Souter, Stevens, and Rehnquist were in the majority. Justices Thomas, Scalia, and Kennedy were in the dissent. And Justice Kennedy, in his dissent in that case, accused the court of having abandoned the proud tradition of free and open discourse. I think, as probably all of you are aware, 4 of the justices who were in the 6-person majority in Hill are no longer on the court. All 3 of the dissenters are still on the court, and the keys are really Justice O'Connor having been replaced by Justice Alito. So even if you assume that Justices Sotomayor and Kagan, I think it's a fairly safe assumption, could vote to uphold the law and join Justices Ginsburg and Breyer, that still doesn't get you to 5. I think sort of even more importantly for the supporters of the law, this is a court that hasn't really found any controversial speech yet that it is willing to find, that it's not willing to allow. And so it had the dogfighting videos in United States versus Stevens, violent video games in Brown versus EMA, the Westboro Baptist Church in Snyder versus Phelps, and then 2 terms ago now, it held that Congress cannot make it a crime to lie about having received military honors. So, sort of between the current lineup of the court and the propensity to support all speech, no matter how controversial, this too could be another case that the court took to reverse. The second case that's on the court's docket is one that it granted at the end of June, right before it took its summer recess, and then quickly certified a question to the Oklahoma Supreme Court. It's a case called Klein versus Oklahoma Coalition for Reproductive Justice, and it's a case involving restrictions on medical abortions, which are abortions performed using prescription drugs rather than through surgery. The Oklahoma law allows medical abortions. It allows doctors to prescribe these abortion-inducing drugs as long as they use the FDA-approved labeling prescriptions. So it prohibits doctors from going off-label, which is a problem from the point of the challengers to the law because, as I understand it, virtually all medical abortions in Oklahoma and elsewhere are performed using an off-label formulation because doctors believe that it's safer for their patients and because it allows abortions to be performed further on into a woman's pregnancy. So the Oklahoma Supreme Court agreed with the challengers that the law was unconstitutional. The Supreme Court granted review and then immediately asked the Oklahoma Supreme Court to weigh in on the scope of the law, whether or not, as the challengers claim, it would outlaw virtually all medical abortions in Oklahoma. The Oklahoma Supreme Court was scheduled to hear oral arguments sometime in October. Do you know, have they happened yet? I don't know. They're supposed to happen sometime in October. As long as the case got back to the Supreme Court by mid to late January, I think there's a very good chance that it could still be on the court's docket this term. Medical abortions are one of the current flashpoints in the debate over abortion. They are abortions that can be performed without women having to go to clinics, which have become fewer and far between. And as the previous case, the McCullen versus Coakley case demonstrates, women may not want to go to a clinic because they may fear encountering protesters. So those are sort of reasons why supporters of abortion have really focused on this case as incredibly important. It's not going to be one, to be sure, in which the court is going to overrule Roe versus Wade, but it could be another case in which the court puts, if the court were to approve the restrictions in the Oklahoma law, could sort of whittle away at a woman's ability to obtain the abortion. The next case I want to talk about is sort of the ultimate in legal nerd excitement. John Elwood, who writes for our blog and for the Volokh Conspiracy, has called it catnip for law nerds. It's a case called NLRB versus Noel Canning, and it's a challenge to the president's ability to make recess appointments. but it really is sort of a fundamental battle about separation of powers. The Recess Appointments Clause is in Article 2 of the Constitution, and it allows the president to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their session. And you can imagine when the Constitution was drafted that this was the sort of thing that was pretty darned important. You had senators who would go off to their home states during the recess by boat or by horseback, so they can't return quickly. There's no phones, there's no email, and there could well be scenarios in which there's a vacancy and the president has to fill it quickly, and this would allow him to do so. Presidents, even in the modern era, have used it fairly consistently, and so this is not a Republican-Democrat issue. I was involved in several challenges to one of President Bush's, the second President Bush's, recess appointments to the 11th Circuit. And this was a case we filed several different cert petitions and amicus briefs asking the Supreme Court to weigh in. The Supreme Court ultimately decided that it ultimately denied cert in all of them. Justice John Paul Stevens wrote an opinion that accompanied the denial of certiorari that said, in essence, we're not going to grant review right now, but this is something that we would expect wouldn't be used very often. And it was not used that often after that. But then the issue sort of faded away as it became clear that, at least at that point, the Supreme Court was not interested in the case. This was a case that was brought by a soft drink bottling company from Washington State named Noel Canning, which was in a dispute with its labor union over a 40-cent per hour raise in its employees' contracts. And the union took the dispute to the NLRB, which ruled in the union's favor. So Noel Canning took the dispute to the U.S. Court of Appeals for the D.C. Circuit, challenging not only the merits of the D.C. Circuit, of the NLRB's decision, but also whether or not the decision was valid, because several of the commissioners on the NLRB at the time had been recess appointees. And so the D.C. Circuit's decision raised two fundamental questions, which the court has never considered before. And the first is, what does it mean for the Senate to be in recess? And the second is, what does it mean for a vacancy to happen? And the D.C. Circuit read the clause very narrowly. It said that recess only happens between annual sessions of Congress at the end of the year. It's not enough that everybody is out of town. That's not a recess standing alone. And the second question, it answered by saying that the vacancy has to be created during the recess. It's not enough that there happens to be a vacancy during the recess. And so it held that the decision was invalid because the commissioner's recess appointments were invalid. The federal government filed a cert petition, and at this point, A, it was the federal government asking the court to hear the case, and B, there was now what we call a split in the circuits. The 11th Circuit had held that the recess appointments were constitutional, and the D.C. Circuit had held that they were unconstitutional, which dramatically increased the likelihood that the Supreme Court would weigh in, which it did. This is a case that will be argued sometime in the early winter, and it obviously has important implications for the NLRB, but also, particularly given the current political climate, really significant implications for the balance of power between the president and the Senate. We've seen with all of the gridlock that's going on right now, that a very small minority of senators can block confirmations, and so at the point that the court, if it were to follow the D.C. Circuit's lead and read the recess appointments clause very narrowly, that would really shift the balance of power over to the Senate, which would know that it could comfortably block a lot of the president's nominations, knowing that he or she could not make a recess appointment. Two more grants that I want to talk about really quickly that are also both sequels of sorts. The first was the greenhouse gases case that the court granted last week, involving the EPA's authority to regulate stationary sources like power plants of greenhouse gases. The trade groups have told the court that this would be, if upheld, the most sweeping expansion of the EPA's authority in its history, costing tens of billions of dollars per year. And then yesterday, the court granted certiorari in a case called Hall versus Florida. In 2002, it had a case called Atkins versus Virginia. It held that it's unconstitutional to execute an individual who is, to use the legal term, mentally retarded, but it did not provide any guidance on how states should decide what it means to be mentally retarded. And so this is a case in which a Florida death row inmate was tested and is found to have an IQ of 71. Florida's threshold for mentally retarded is 70. The test has a margin of error of plus or minus 5 points. And so it's a question about sort of the legal standard for determining whether someone is mentally retarded. Two other sort of sets of related cases that I'll talk about very quickly, and then we can move on to questions. The Affordable Care Act is almost certainly going to be back at the court again this term, although a different provision of the Affordable Care Act. This time it would be what's known as the birth control mandate, which requires employers who have 50 or more employees to provide their employees with insurance that includes access to birth control. And there are rules that exempt religious institutions like churches and some nonprofits associated with religious institutions from having to comply with this for religious reasons. This case is about whether or not for-profit corporations that are wholly owned by families who have strong religious beliefs and object to the use of birth control can refuse to comply with the mandate. To put it another way, in sort of Citizens United terms, is whether or not for-profit companies can have and exercise religious beliefs. I talked in the recess appointments context about a split in the circuits. There is exactly that kind of split in the circuits here. The 10th Circuit held in a case brought by the craft stores Hobby Lobby that Hobby Lobby could have and exercise religious beliefs and did not have to comply with the mandate. The 3rd Circuit has said that a Pennsylvania woodworking company that is owned by a Mennonite family does not have religious beliefs. So the United States and the Conestoga Specialties, which is the name of the woodworking company, have both filed cert petitions. Hobby Lobby in the 10th Circuit case is represented by, among others, Paul Clement, who argued the individual mandate case. And Hobby Lobby has done, in the last day or so, what's known as acquiescing. It has agreed, even though it won in the lower courts, it has agreed with the government that cert should be granted in its case. So these cases could be before the justices at their conference as soon as next month and would be argued in sort of late winter or early spring. One last issue that I want to talk about is cell phone privacy. There were 2 cases, one of which almost certainly seems to be heading to the court, once again, for the idea that there is a circuit split, and it's whether or not when the police arrest you, they can search the contents of your cell phone and then use what they find on your cell phone against you. So the United States has filed one of these cert petitions in the case of a drug dealer. They arrested him for selling 2 bags of crack cocaine, tried to find his address on his cell phone without a warrant. They found his address, then they got a warrant to search his house where they found his larger drug stash. The First Circuit held that because the original search of his phone was unconstitutional because the police did not have a warrant, all of the evidence had to be thrown out, including and essentially Worry's conviction. The other case is a cautionary tale for criminals. Riley versus California. David Riley was arrested, pulled over for having tags that had expired on his car. They asked for his license. His license had been suspended. They searched his car. They found guns underneath the hood. At that point, they arrested him. They took his cell phone. They looked at his cell phone and found texts which suggested that he was in a gang. They looked more on his cell phone and found photos and videos that he had taken of a gang-related drive-by shooting. So he was arrested on charges, and the California Supreme Court, disagreeing with the First Circuit and several other courts, said that the search of his cell phone did not violate the Fourth Amendment. So it seems inevitable that the court is going to have to take on this issue. Many of you who follow the court know that the justices are not very good with issues of technology. Justice Kagan has given an interview recently in which she said that the justices still don't really do email amongst themselves. But this, again, and particularly since it's the United States asking them to take the case, is one that they're going to have to take and try to grapple with. So at that point, I probably could say more, but I want to make sure that we have time for questions and comments.